Good evening, everybody. My name's Matthew Harding. I'm the Deputy Dean of the Melbourne Law School. And on behalf of the Law School, it's a real pleasure to welcome you all here this evening for this seminar on the future of law reform. Let me begin by acknowledging that we're meeting this evening on the lands of the Wurundjeri people of the Kulin Nation and pay my respects to their elders past and present. And let me also acknowledge that the Wurundjeri people have practiced law, and dare I say it, law reform, in this place for thousands of years. I pay my respects to any Indigenous Australians who are here with us today, and any First Nations people who are not Australian. Now, this seminar is the third in a series of public seminars that the Australian Law Reform Commission is holding around the country as it maps out an ambitious agenda for 3 to 5 years for law reform in this country. The first two seminars were held at the University of New South Wales and at the Australian National University, where I'm told that there was lively discussion of constitutional law reform, law and technology. And we're delighted that the series now moves to the Melbourne Law School at the University of Melbourne, where this evening there'll be discussion of constitutional law and immigration. The work of the Australian Law Reform Commission and other law reform commissions in this country and elsewhere is critical to the health of our legal system and the maintenance of the rule of law. And it's really wonderful to see the Commission seeking the involvement of the Australian public in this important work through events such as the seminar this evening. I would like to acknowledge Aftab Hussain. Where are you, Aftab? He's at the back there, who's performed a mighty labour of work in getting this event organised. And we thank you, Aftab, and acknowledge the work that you've put in this evening. Now, I am not able to hang around for terribly much longer because I have 2 young children and a beleaguered childcare worker waiting for me at home. But I wish you and the distinguished panel all the very best for your deliberations this evening, and I look forward to learning about the outcomes in due course. And so it remains only for me to call upon Justice John Middleton of the Federal Court and the Law Reform Commission to introduce our panel and to get the ball rolling this evening. Thank you, Justice Middleton.
I'm very pleased to be here to introduce this evening's panel to you all on the future of law reform. We're dealing with today the Constitution and migration law, large topics individually, but we'll try and do the best we can in the time we have got. I too acknowledge the traditional custodians of the land in which we're meeting today and pay my respects to the elders of the Kulin Nation, past and present. Also extend the respect to the Aboriginals and Torres Strait Islanders who are with us today, if not in this room, by the streaming. The Commission is very proud of its history of consultation, and this is part of this particular aspect of consultation which we're going through today. With this, in this spirit, we're asking really for input from you and those who are here today, either physically or on the live stream, to work out what areas of law are not working, either in whole or in part, and to get some input as to what we should be focusing on. There is often lack of clarity with laws, their operation has side effects that are not perceived, and all those matters need to be considered. I look first to the Constitution. As you all know, took effect in 1901 and has been the subject of quite a bit of debate amongst a number of stakeholders, if that's the right word. There have been 44 referendum proposals that have been put to the Australian public since that time, and only 8 of those referendums were successful. But in recent times there has been an increased interest in altering the Constitution. Some of my judges talk about it, colleagues. wanting to increase the age in which we have to retire. Don't think that's necessarily a good idea. But there are perhaps more important matters that need to be dealt with in the Constitution and by amendment. The Constitution itself has never been the subject of a reference of the Australian Law Reform Commission. But obviously it impacts upon the work of the Australian Law Reform Commission. Because when we look at specific areas of matters to reform, we have to do so with the Constitution in mind and what restraints we have. And the recent family law inquiry indicated, for those who have had the opportunity of reading it, lengthy as it is, you'll see the difficulties of federalism in that particular area where you have state courts and federal courts, and how one deals with the disputes that arise in families, including, unfortunately, the issue of abuse of children and the way in which the courts interact in that particular area. Apart from the Constitution, which in itself, as I said, is a challenging matter to deal with, as far as reform is concerned, the legal framework of migration law is equally challenging. It's not quite as bad as the Tax Act, I don't think, but there are many, many sections in the Migration Act 1958, and clearly one of the largest pieces of Commonwealth legislation. It's been amended many, many times, as you all know, and the courts have had to grapple with some of the issues dealing with the role of the courts and the supervisory role of the courts, and the various policy issues that arise in relation to migration. Now, we're very lucky to have panel members who are going to lead this discussion and explore various areas of law reform. We're going to have, throughout the presentation, an interactive software called Slido, and whether you're here in the room or listening online, you're invited to type in your questions to the panel during their presentation by logging on to slido.com and entering the code capital A ALRC, Australian Law Reform Commission, ALRC. After the panel presentations, you will also have the opportunity to ask questions in the more traditional way. And at the end of the session, we're going to be able to vote for the highest priority of law reform topics. So you're going to be very much involved in this exercise throughout the next hour. I want to introduce the panel members very briefly. I think you'll all know them all very well. Professor Cheryl Saunders is Professor Emeritus here at the Melbourne Law School. She's a President Emeritus of the International Association of Constitutional Law, former President of the International Association of Centres for Federal Studies, and a former President of the Administrative Review Council of Australia. Obviously very well qualified to begin our discussion tonight. We then have Professor Stone, again well known to you all, holds a chair at Melbourne Law School, which is also Kathleen Fitzpatrick Australian Laureate Fellow, a Redmond Barry Distinguished Professor and a Director for the Centre for Comparative Constitutional Studies. Together with Professor Cheryl Saunders, she is the editor of the Oxford Handbook on the Australian Constitution. We're grateful to have her here too. As far as immigration law, well known again, is Professor Susan Kneebone, Professorial Fellow at the Melbourne Law School. She researches in the area of international migration, nationality and citizenship law. In 2012, she was elected Secretary of the International Association for the Study of Forced Migration and was appointed to the Senior Research Associate Network and Publication Board of the Refugee Law Initiative at the University of London. And finally, we have Ms. Katie Robertson, again, sure well known to all of you in her field, as a Legal Director of the Human Rights Law Centre based in Melbourne. She leads the Centre's work advocating for the rights of refugees and people seeking asylum. Ms. Robertson has extensive strategic litigation advocacy experience, has undertaken humanitarian work, and has acted as a senior advisor to a federal senator who has represented victims of the Khmer Rouge regime in Cambodia. We're delighted to have her present today. So without any more from me, I think we're going to start with you, Professor Saunders. Off we go.
Thank you very much, Judge. Is it on, everybody? Yes. And welcome, everybody. Thank you very much for coming to this seminar this evening. I just want to make three broad points about constitutional law reform in contemporary Australia. First of all, some of the most significant aspects of our system of government that I think need attention do not require formal constitutional change. I would include in that category the extent of reliance by the Commonwealth Government on its executive power and its power to spend, and the extent of the centralisation of the Australian federal system, precluding us from taking advantages of the rather deeper system of democracy that it offers. But both of those sets of problems require legal and political cultural change, deserving our attention as citizens, but are not really suitable for law reform in the familiar sense. My second point is an obvious one in a sense. Constitutional law reform differs from other kinds of law reform because of the requirement for a referendum. The need for a proposal to be supported at referendum fundamentally alters what a body like the ALRC might do in relation to constitutional reform. I take the view that the reason why constitutional change has been so conspicuously unsuccessful in Australia is because too many proposals are presented to the people from on high in a top-down process. I think it's likely that many, if not all, proposals for change need to be developed in a way that involves the people more creatively at a formative stage. The difference that this makes can be seen from the process that led to the Uluru Statement from the Heart, a popular deliberative process that produced a very appropriate proposal, quite unlike those that had been canvassed up until then. This line of thought suggests that we should think of ways of involving people across the country in a series of citizens' assemblies or such like to explore the constitutional changes that might be useful to deal with real problems. There would still, of course, be a role for a body like the ALRC, but it wouldn't be needed to produce recommendations necessarily. A useful role would be to produce informed, accessible and impartial options for change to inform the citizens' assemblies. Thirdly, let me illustrate this by reference to one current problem that I think clearly requires formal constitutional change of some kind. That problem concerns the disqualifications for members of the Commonwealth Parliament in Section 44 of the Constitution, and in particular, the multiple citizenships disqualification. I say it's a problem because of the huge number of Australians that it disqualifies or discourages from candidature for election. But on the other hand, there seems to be significant uncertainty in what is presently a rather suspicious and angry electorate about whether the section should be changed at all, and if so, what changes should be made. This would seem to me to be a most appropriate question for discussion at a grassroots level in forums of some kind in order to try and find a broad-based and satisfactory consensus about what to do. I can imagine that the ALRC could support such a process by producing an options paper that draws together past Australian reports, puts Australian experience in comparative context, reviews the practical difficulties that have arisen and can only worsen, and suggests a range of possibilities for the way forward. Thank you.
Okay, thank you. I actually want to pick up where Cheryl left off, but I want to focus my remarks on an area of constitutional law in which I have a strong interest, partly because of my strong interest and partly because it is so much in the news at the moment. So I want to talk to you about freedom of expression. Freedom of speech and freedom of expression are just never out of the news at the moment. Whether you're on the left or on the right of politics, you will find that from Section 18C of the Racial Discrimination Act through to the purported crisis in universities, through to the problems posed by our national security regime, through to the problem of press freedom, everybody agrees that freedom of expression is important and under threat. Now, there are a series of common reactions to this, and they usually proceed like this. Number one, Australia is the only democracy without an express right to freedom of expression. Not quite true, but close enough. Number two, the constitutional protection for expression we have is too weak. The doctrine known as freedom of political communication is thought not to be as strong as an express right of freedom of expression. And number three, We therefore need to align ourselves with the rest of the democratic world and adopt, preferably in constitutional form, but maybe just in statutory charter form, a right of freedom of expression. My argument today will be not so fast. I want to argue that the freedom of political communication is actually a lot stronger than we understand it to be, and that an express right of freedom of expression is weaker than is often claimed, so that the two are much closer together. I do think that there is a case for reform, but it needs to be very carefully done, so let me explain. The Australian Constitution is recognised to guarantee something called political communication by virtue of the fact that it includes in it provision for the Houses of Parliament to be elected by the people and for the executive to be held responsible to that Parliament. Now, it's often said that precisely because there is no express piece of text that mentions freedom of expression or free speech, that this therefore makes the protection weak. However, my view is the statement that the Constitution requires a state of affairs in which we can properly choose our representatives and can properly hold the executive and the departments operating under them accountable is a profound democratic statement. It has enormous potential. Indeed, I think it has the potential to include anything that you would see in a free speech regime in any other constitution worldwide. Now, it hasn't done so, in fact. But that's nothing to do with its legal structure, but rather something else, which I'll get to in a minute. But before going on, I want to make a second point. And that is, if we were to adopt an express right of freedom of expression, it would have its own kind of weaknesses. It would likely be subject to a general kind of limitation that would allow laws that impose some kind of reasonable limitations on freedom of expression. All our closest constitutional cousins approached freedom of expression in just that way. It would not address in detail the particular questions that are concerning us at the moment, and exactly how controversies over freedom of expression or hate speech or national security would be resolved remains unclear and would only ultimately be worked out over time by the judiciary. So, having said that, wanting to convince you that these two forms of protection are much closer than is commonly thought, I do think that there is a special weakness in the freedom of political communication as we have it. But it's not legal, but political or cultural. That is, I think that there is a measure of judicial caution around its application that arises from some misgiving about whether it perhaps should ever have been recognised in the first place. And secondly, I think that there is just a level of popular disengagement among the Australian people. It is striking that political debates in Australia about freedom of speech do not reference the Constitution really at all. There's freedom of speech that we argue about, and then there's a technical legal constraint in the Constitution. Now, I think more effective protection of freedom of expression would require both of those cultural matters, political matters, to change. However, they're not going to change unless constitutional legal reform is approached in the kind of way that Cheryl Saunders just explained to you. That is, it needs a real proper, deliberative, bottom-up engagement with the Australian people about what they really want. And it might not be an express right to freedom of expression in the Constitution. It might be something else. I don't know. I do think it's worth asking the question and not making a top-down assumption about how these problems that we should be dealt with. So I think that responding to the constitutional problems relating to freedom of expression goes well beyond law reform as we ordinarily conceive it. In the meantime, can I suggest there's lots that can be done at the ordinary law reform level to things like whistleblower protection, protection of journalistic sources, and unless and until we're really prepared to undertake that deep and proper engagement about freedom of expression, I would think it's on those statutory matters that we ought to focus.
Is this on? Yes. Well, Thank you very much for the opportunity to speak tonight. I'm delighted to be here. I was rather puzzled by the combination of constitutional and immigration issues, because I think that immigration issues are so inherently political because they involve ministers' discretions that it's really very hard to discuss it in the constitutional context. So I thought what I would do would be to remind you what our constitutional heads of powers are and how these heads of power have played out in other countries with different political contexts, ramifications, and move on from there to suggest some other practical ways to move things forward. So we have two constitutional heads of power on immigration matters in this country, and let me say I noted also that the title is immigration, not emigration, and I wondered whether that exclusion of emigration was deliberate or not. I see the title of migration as much broader than immigration and immigration, as being a more inclusive one. So we have two heads of power and two major problems in this country. We have the aliens and naturalisation power. We have the immigration and immigration power. We have no constitutional head of power for citizenship, and the Migration Act is based on the aliens power, and the Migration Act has essentially become an instrument for broad discretion and exclusion of people. So one of the problems which Cheryl has referred to is that this is not necessarily a matter for constitutional amendment. In thinking about this issue, I thought, well, what could one do about the heads of power? Could we change the aliens and naturalisation power to one of citizenship and nationality to make it a more inclusive concept? But and a little look at a comparative jurisdiction such as Canada shows that it can be done in a different way. It's not just the actual words of the head of power, it's the way in which the courts over time, the whole culture of constitutional interpretation around this power has developed, which has so infused the Migration Act. I think that is the great malaise in our system. If you compare the Canadian system, for example, they also have a head of power for naturalisation and aliens, but they also have an Immigration Act, which is also an Immigration and Refugee Protection Act. And just to show you the difference between the two migration legislations, the objectives of the Canadian Act are to permit Canada to pursue the maximum social, cultural and economic benefits of immigration. I could continue. The second one says to strengthen the social and cultural fabric of Australian society. Compare that with the Australian Immigration Act, which is an act relating to the entry and presence in Australia of aliens and the departure or deportation from Australia of aliens. The object of the Act is to regulate in the national interest the coming into and presence in Australia of non-citizens. And so it goes on. It provides a system of visas. It requires non-citizens and citizens to provide personal identifiers. So we see immediately that our Migration Act, in contrast to Canada's, is one that is aimed at controlling who comes into the country, at ensuring that security issues are well covered. Now, I'm not suggesting for one moment that these are not important issues, but I do think that we do have a problem of culture around migration law and migration administration in this country, which is not necessarily going to be solved by a constitutional amendment. Because if we think about other jurisdictions which have similar approaches to migration, such as the USA, we see that those powers, those constitutional powers, are also supported by prerogative powers or plenary powers as they're known. So one of the problems with migration law and the Constitution is that it's not clear that the Constitution is the sole source of power, and that's what my little comparison with Canada was intended to show, that it, as with a Constitution, so with a whole bureaucracy, a certain culture grows up, and how we reverse that culture, I don't know. As I say, I toyed with the idea of replacing the naturalisation and aliens power with one to do with citizenship and nationality to make it a more inclusive thing, and to try and avoid some of that appallingly complicated litigation and jurisprudence that we've seen coming out of our High Court when we have statements about the stream cannot rise higher than the source, and talking about the false citizen-alien dichotomy. We have one of the most convoluted systems of migration law jurisprudence, as far as I'm aware, in comparison to, for example, the UK, which has a common law constitution. So I start with a little bit of scepticism or concern, shall we say, about the value of constitutional reform. Another enormous issue in migration law is the issue of migrant workers. And the issue with this particular area is that it is generally regarded as an issue of labour law rather than migration law. And yet this is not an issue which is particularly a constitutional law issue. So those are my two of my comments. My third comment would be, again, using the comparison with Canada. You have in the Canadian Constitution an embedded Charter of Rights. You also have, for example, in the European Union, the European Convention on Human Rights, Article 8, the right to privacy and family life, which has been used indirectly as a way of bringing in migration law. So one positive suggestion I could make is that our constitution could include some, if not human rights, some definite guarantees for the rights of temporary migrants in our legal system. So I'll finish there and pass on to the next speaker.
Thanks. Thanks for having me. So I'm not a professor, but it's wonderful to be in the company of giants tonight. I am a practitioner that works with a lot of refugees and people seeking asylum, and I wanted to provide some perspective in terms of what it's like for those people in Australia and in our detention network offshore at the moment. And I'd really echo Professor Kneebone's observation. My key observation is that immigration law in Australia is inherently political. We only have to look at the Migration Act to understand that. It changes frequently. It contains over 500 sections. It's been amended over 30 times since 2010. And I can tell you, as a lawyer practicing in this space, it's an absolute nightmare to deal with that is constantly evolving. And it's been my experience practicing in this space and running a number of cases in this space. I've had instances where, while a case is on foot and we think we've found a way to challenge a certain provision within the Migration Act, where the government of the day says, thanks for pointing that out, we're going to amend the legislation while your case is on foot and while your case is currently being considered by judges, which for me is a very concerning interference with the separation of powers, but also, unfortunately, the political climate we're in Australia and have been for a number of years, where there's really been no effective opposition in this space. So you see the government changing it and the opposition essentially rubber stamping it. So why do I mention this? Well, the work I do would be my obvious starting point tonight, that the key order of business for Australia, where we sit at the moment, is repealing Australia's offshore detention regime. However, I use that as a starting example because it's not as simple as making a recommendation for this amendment and the relevant sections of the Migration Act to be amended, given this is an inherently political issue, and I think that's a theme we've seen come across from all the speakers. It really requires a broader rethink about how we can use the law and law reform to create the environment for policy change. We need a radical rethink in this country around the debate we have concerning the way we treat people seeking asylum. But I do think there is some positive scope to do that. And I'll come back to why I think that this rethink is important. Look, I have a long wish list of areas that I think there is scope for law reform. I'm going to list a couple of top line areas, but I'm going to finish on one that I think that there is some real potential for reform in this space. I've mentioned an end to offshore processing, which is a difficult one from a legal perspective. There's a need to look at creating a fair process for claiming asylum in this country. We have an obvious problem for a number of my clients at the moment where, depending on your mode of arrival in this country and the date in which you arrived to seek asylum, you're actually not even allowed to claim asylum in this country, which raises all sorts of concerns around our obligation under human rights and international law. There's a real problem in terms of accessing permanent protection for people that are able to access asylum in this country. Again, a number of people, as we sit here tonight, are currently on temporary protection visas. Particularly children, this creates real problem for people being able to rebuild their lives in safety and plan for their future. There's issues in relation to access to citizenship, which Professor Newbone could talk about with her expertise. There's concerns we've got around reforming the way the immigration detention network works in Australia. Obvious concerns that have been prosecuted over many years around mandatory detention. Also conditions of detention in Australia. It's a strange one to think about, but there's no legislation regulating conditions of detention in Australia. And I ran a case a couple of years ago where we were looking at Christmas Island Detention Centre and arguing that the conditions there were not adequate, particularly for children. And it's interesting that we have a number of regulations and safety nets regarding people in prison in this country, but it's very hard to understand what is an appropriate level of care for people in immigration detention. Broad discretionary powers by the Minister that have been touched on tonight, but are deeply concerning beyond the immigration space. But lastly, where I just wanted to talk about was actually in relation to family reunification pathways for people that are in Australia, either through the SHP, the Special Humanitarian Program, but also people that have arrived in Australia are on temporary protection visas at the moment. The reason I mention this, and I think it's worth exploring, is I actually think this is one area where we have the benefit of actually encouraging that rethink in this country about how we view refugees and people seeking asylum, because everybody understands the importance of family and everybody can relate to the idea of being separated from family members, including being separated from parents or children or loved ones. So we are doing some work at the Human Rights Law Centre at the moment. We're working on a report that will be launched later this year looking specifically at this issue, and the Refugee Council of Australia have done a lot of fantastic work in this space, but looking at ways in which we need to both lift certain restrictions on the ability of people who have arrived by boat in this country to sponsor their family members, but also look at creating some positive and meaningful changes to the system as it currently stands to expedite the process for people and make it more accessible. This is particularly an issue for people that are on temporary protection visas that I mentioned before, in that they're not actually allowed to sponsor family members. So I'll leave it there, but just to point out that I think we've got to rethink the way we approach this issue, and it's through family links and human connections that I think we have the potential to do that through law. Thanks.
Thank you very much for each of our panellists' comments. So I think we're now over to questions or comments. Any contributions to be made? So I'll start with the present audience. Yes, please.
In relation to the subject that's just come up, how do we establish citizen assemblies? I'd like to follow up on the two speakers in particular who talked about starting with the population and then working through to a constitutional...
Sorry, I think you may have to have a microphone. Is that right? Sorry about that. You may like to start again, sorry.
The two people who spoke about starting from the people. Is it working? Yes. And say, my experience, long experience with change, going back right to 1999, but in particular I took part in 2001, I think it was, of the Constitutional Convention called by Richard Mugabe, where people generally met and talked about the system. Now, what went wrong with that was everybody had agreed that we should become not everybody agreed. The mass of the people agreed against the small number who disagreed that we should become a republic, and that was not followed through. To me, this is the essential thing we have to work out. A, people want us to become a republic, but why? How do we make us a republic? A republic is where rule is by the people, and in our constitution we have a setup which is basically a constitutional monarchy, where the monarch theoretically is the head of state and the Constitution limits the powers. I think that's where we've gone terribly wrong, and we have this situation now where the executive government gets into government and operates as it has after the last election without any reference to the Parliament. The Parliament's elected by the people. The Parliament should be the body that selects the government. Our government has been operating for nearly a month as though there was no Parliament. It wasn't responsible to Parliament. It's acting like a monarch, and that's because the Constitution allows that. That's the bit we have to make a major change the whole setup of what our Constitution is.
Thank you.
In my view.
Do you want to make any comment about the executive and how it operates?
No, but I will make a comment about the Republic. I wondered about touching on the Republic myself in my comments because I think that is another issue which sooner or later we will need to deal with as a country. It doesn't seem to be immediately on the agenda. And that when we do, we will need grassroots discussion. One, about what a republic actually means, which is the issue that you've just brought up. And secondly, what would a Republican Australian look like, including how do we go about getting our head of state? And those are issues that we will desperately need to have discussed at the grassroots. It will be a complicated process because it's a very complicated system now, and to explain it to people is not easy. But it's not impossible to work these things out in that way. So thank you for raising it.
I'd like to say one thing. So my sense about the 1999 process is that it was probably too elite, even though there was a constitutional convention process, it was probably too elite to succeed. I also think, and this is maybe a controversial thing to say, that the change that was put to the Australian people wasn't big enough. I think that's a controversial thing because I think the failure of successive referendums in Australia has led us to be really quite averse to putting significant change to the Australian people. But actually, I think the Australian people, my sense is, and it was very much confirmed through the process that led to the Uluru Statement, they don't want to be asked to vote on technical and symbolic changes. If you're going to put something to them, it actually really needs to be something that you can explain makes a difference. And we ought to consult the Australian people very thoroughly on what that should be. But I think going too small is a recipe for failure, is my sense.
Yes, please, Professor.
Sorry, did you want to say something else? No. I'd just like to comment on your question, not directly, but I want to do so in the context of emphasising the fact that our migration legislation is based on the alien's head of power. And this concept of alien is tied to the idea of a sovereign with subjects. It's an outmoded concept, and that really was part of my thinking behind this. We are no longer British subjects. We haven't been for a long, long, long time. We are a multicultural society. Canada mentions the idea of multicultural and languages, but of course they've got a particular history, which we don't have. And so part of my thinking behind the suggestion that the naturalisation and aliens power be replaced by one on citizenship and nationality was to recognise, to embrace the inclusiveness of the Australian population, which I think our ruling people do not recognise. I think they have their heads in the sand quite often.
Does anyone want to answer the question, the first question there, dealing with
I can talk
Migration
a little bit
Act?
about
Yes.
Section 501.
Thank you.
Yes, Section 501 is an example, in my opinion, of how the Migration Act has really got out of control. The Section 501 cancellation of visa, that's the situation in which a visa can be cancelled on the basis that you've failed the character test. And that it gives a discretion to the minister, which is basically unchallengeable, very difficult to challenge. It arose out of the criminal deportation policy. The criminal deportation policy became a little bit inconvenient, and so Section 501 has become the favoured one. And through use of this power, many people who should not have been deported, who were people who had been, as the older courts used to say, absorbed into the country, who'd become, if not formally in law citizens, but were actually part of our communities, have been deported, and this would undeniably be in breach of their human rights, such as the right to family unity, etc., etc.
Thank you. Anyone? Yes, let's deal with the Citizens' Assembly. Good idea. Yes.
Up there, the question is, how would we establish citizens' assemblies? And the answer is there's quite a lot of experience with this in the world at the moment. The Irish have had some very successful attempts in this regard, leading to some major constitutional changes. The Scots are now proposing a citizens' assembly of a kind. Similar events have been run across France recently and in Belgium. It's an idea that is really running wild around the world. In the Australian context, because we're so geographically large, I think the idea of a single citizens' assembly is probably not as sensible as it might be, that we would need to think of a range of decentralised assemblies across the country, including in cities and regional areas, connected in some way. We at this law school did have a bit of experience with this in the 1990s when we ran the Constitutional Centenary Foundation and ran a series of what we in those days described as local constitutional conventions in collaboration with local government around the country. And I think we ran 50 of those, which ultimately came together in a single convention. So that would be one way of trying to organise a citizens' assembly in a country with Australia's dimensions and making it much more of a genuine exercise that it might otherwise be. There's all sorts of questions about how people are chosen to participate in those meetings. They need to be chosen at random. Of course, there's a lot of argument about how you go about doing that, but it's surely possible to deal with those technical questions.
Well, we've had experience with Royal Commissions, which are national Royal Commissions that go around the country and move around, and you have a number of people in various areas, so it can be done, but you're picking the right people is always an issue. But right, it's always a difficult issue, whatever you want to appoint someone to something. Anyone else? Just some topic that they have on your mind that hasn't yet been raised about constitutional reform or migration reform? Yes. I think you need a microphone. Thank you.
Yes, I just wanted to comment that the British who wrote the Australian Constitution had centuries worth of upheaval and need to defend the kingdom and in fact various monarchies, because upheaval was fairly rampant for many centuries. And I'm wondering, with the changes that are being advocated by you to the Australian Constitution, to what extent are you contemplating that by embedding these changes, are you assuming that there will never be a need to defend Australia the way the British had to?
Want to go, Cheryl?
Well, I don't think we've suggested very many constitutional changes. Rather, we've been talking more about how you go about changing the Constitution in the 21st century, in a very democratic age, and in a constitution that requires a referendum for constitutional change. So the only real proposal that I've put on the table is the Section 44 one. And even then, I think we need to talk to people about how, if at all, they would like to change Section 44. But can I just say something about the British? The British didn't actually write the Australian Constitution. I mean, it's a very interesting dimension of Australian constitutional history that we take wicked advantage of from time to time. That even though the British Parliament did enact the Constitution at the end of the day, it was written by a process which, by the standards of the time, at the end of the 19th century, was remarkably inclusive. And that provides a basis upon which we can build. And that's one of the reasons why I think that it's worth thinking quite hard about how we might get this bottom-up process working.
I didn't hear. Could you speak up? Sorry, in the mic. Sorry. Thank you.
It was a different form of inclusivity to the one being contemplated today, the one when the Constitution was founded.
Yes.
In fact, if I
Yes.
Just add one more thing. It was very much modelled on the US Constitution, and the reason why citizenship was not included as a concept in the Constitution was because of the specific comparison with the US. They thought it was far too premature. They wanted to keep us as British subjects.
Anyone have any other suggestions? Yes, please. And the microphone will come to you.
I think Professor Saunders mentioned the Uluru statement. I'd be interested in your comments about how that is likely to progress given the election of the new government. Any thoughts about that?
Both of us were.
All right, Professor Stone, do you want to start?
Well, so let me say, I think that it's just too early to say terribly much. But the fact is, with constitutional reform of that nature, is you're going to need very wide-based support. So I don't want to say that it doesn't matter who's in power, but whoever is in power also means you need to get the other side of politics in. And so that's got to be the way forward, I think.
Mm-hmm.
Yes, I mean, I think it's too early to tell what will be done in the immediate future. I think one of the very interesting things that has occurred over the year or so since the meeting in Uluru is that there's been a tremendous process of taking the parchment around the country, talking about it, getting people to look at it, getting people to sign it. We had a wonderful event here which had people like yourselves all coming forward to sign the Uluru Statement or supporting pieces of paper, and that's been a very positive process. And I think one of the things we all need to think about, there's been a very considerable deliberation on the part of the Indigenous people themselves about the Uluru Statement. One of the questions now is how to get the message out, get other people involved and excited about the possibilities that this particular change offers. And it may be that that's the most important thing at the moment rather than what happens in the Commonwealth Parliament.
I thought I saw another hand. Yes, please.
Referring to this question of withdrawal, once you give it and then you withdraw from them, where do these people go back? To the sea. And will it be the same application if he is an original Australian? Will you apply the same law?
Same law?
Thank you.
Maybe like to repeat the question.
So I heard the question.
Yes. Can we clarify the question for us, please?
My question is, if this law gets implemented, in case, if you withdraw the citizenship of an immigrant, where is he going to land?
Yeah, I see. Yes.
Secondly, whether the same law will it be applicable to original Australian if he goes and fights somewhere or the other.
Yes.
So a human right of an individual is going to be violated.
Yeah, understand.
Thank you.
Professor Kneebone, do you want to say anything about that?
Yes.
Yes. The law is actually our law.
The law.
So he's saying when we implement our law,
It's a citizenship stripping issue.
Yes.
Yes.
Yes. Okay, so let's just start with the principle of nationality. Everybody has a right to a nationality. That is what the system of states is about, to ensure that everybody has a right to a nationality. If people don't have a nationality, they are stateless. And so if a person is stateless, and states have signed a convention on statelessness, as they have in Australia's case, we have an obligation to keep that person. It's as simple as that.
Yes, question here. Thank you.
should the Bill of Rights be included in the Constitution, basically like the American Bill of Rights?
So I don't want to say that I'm dodging the question by saying I don't know. But what I do want to say is it's far from obvious that just because we don't have one, that that's what we need. Bills of rights come with advantages and disadvantages, and we can see them illustrated if you look around the world. There are other ways that we can think about protecting rights through our constitutional structures, through our statutory structures. So I guess my only thing that I would say is I don't think we ought to leap from the conclusion that we don't have one to the conclusion that that's going to be a straightforward answer to our problems. Right? I really don't think it is. Even if we decided to implement one, what it's going to mean is going to depend on how it's developed over years and years and years of litigation, and that is going to depend on the deeper political and constitutional culture with respect to rights. So I think that might be the useful place to start, rather than to assume that we have this sort of ready-made solution on the shelf that we can just insert into the Australian Constitution. And that's because I think processes are so important. All that I think really can be said at this point.
So it depends, it's an evolutionary thing basically, and it takes time through a process of decision making by the government, by whoever's...
And it takes deep consultation and deliberation by the Australian citizenry as to how they want their rights protected, okay? Because the Bill of Rights is one very particular form. It's a form that, at least in its sort of most classic form, says that what we want to do is give the judiciary the institution to be principally responsible for it.
Individual rights, of your own individual rights, that encompasses what the Constitution is all about.
Well, if we want to constitutionalise them within our system, the likely response would be that it would therefore become the job of the judiciary to tell us what they mean, right? So a Bill of Rights is going to be expressed in general terms. We're actually going to disagree about what they mean in particular cases. And then we will be asking one of our institutions to determine what they mean in particular cases. So the meaning of the Bill of Rights will evolve over time. And it's precisely because of that I think at least some caution is appropriate before we simply assume that this is the form of rights protection that we want. And there are other forms available, including human rights legislation of the kind that we have. They have their own problems. We do, in fact, spend hours talking about this with our students at Melbourne Law School, and I won't take us all the way down the path. I really don't want to dodge the question by saying I'm not going to give you an easy answer. I just don't think the answer is easy.
Ms Robertson, do you want to answer those questions there dealing with migration?
Oh, sorry.
There's the one dealing with judges, so I'll leave that alone.
I just wanted to follow on from that point. I agree wholeheartedly that it is a question that needs careful consideration, but it's one I think I'd encourage everyone to actively engage in on that issue. And I think rights of refugees and people seeking asylum is an area where there's some obvious gaps in terms of potential protections for people. But I will answer, is immigration law really a constitutional problem? Are most of the issues with the Migration Act issues that Parliament could fix if it wanted to? I'll defer to Professor Kneeburn on the constitutional question, but I think that the point we've both been making tonight is that I would say the Migration Act, as I've said, is inherently political, and Parliament has broad scope to amend a number of concerning provisions in that Act, and they could do it relatively easily. Equally, the broad discretionary power that the Minister currently has under that Act means that it's a he at the moment, means that he equally has a lot of power to make changes on behalf of individuals, which is also quite concerning. So with the stroke of a pen, he could do a number of things, both bring people to Australia from Nauru, Manus Island, lift the bar on certain people being able to even access protection in Australia. So I would argue that there are a lot of issues that the Migration Act, that could be addressed in the Migration Act as a result of politicians. But that being said, there's an important need for law and law reform to drive that question.
And what about the first question? I'm not familiar with the UK system. Is they've got a tribunal, I take it, have they?
Yeah, I can comment on that.
Thank you.
explaining what we do in Australia, we have, what is it called now? It's the AAT. Things have changed since I last taught migration law, actually. But it is still embedded in the executive arm of government. That much I do know. And that, of course, is one of the three basic branches of government under our separation of powers doctrine, which is of course endorsed by the Constitution. So the UK doesn't have quite the same constitution as we do. In fact, they don't have a written constitution, and the Immigration Tribunal does have some extra powers in particular in relation to making, because I know because I'm supervising a student who's doing a thesis on the topic, it determines, it makes decisions which can be binding on other courts. So it is slightly different. So the answer is we can't be quite like the UK because we have a strict separation of powers as endorsed by our Constitution. Maybe the second one I could also comment on,
yes,
because I think that's really what I have been talking about. Is immigration law really a constitutional problem? Well, I guess I wasn't necessarily terribly clear in what I was saying. I would say yes and no. It is a constitutional problem in one sense, in that our migration law is based on, our Migration Act, our basic law is based on the alien's constitutional head of power. That head of power happens to have been interpreted by our judges and implemented by our executive in a very, very exclusive way, we could say. If you look at the history of the constitutional heads of power up to World War II, which I happen to have a personal fascination with, you'll see that the judges, when they applied the immigration and immigration power, applied a much more inclusive approach, and there were many split decisions. In the very first decision, Rob Telms and Brennan in 1906, the court was basically split on or didn't really decide the question of which constitutional head of power would prevail. But as World War II finished and things chugged along with the Lim decision, for example, the indefinite administrative detention decision, the alien's power became entrenched. So I'm suggesting in a way that a circuit breaker to this culture of exclusion that we have in our Migration Act, which stems from the Constitution, is to make the aliens and naturalisation power one into one that reflects more what we need in Australia, something to do with citizenship and nationality, a more inclusive one.
Yep.
But
well,
having... sorry, I could go on.
Yeah. We may, I think Michael's given me the wind-up, are you? Do you want to do a Slido poll? Is that able to be done? Or yep. So would you explain that, Michael?
Good evening, everyone. Michael Payton from the Australian Law Reform Commission. Thank you so much for your attendance tonight, whether in person or online, and thank you also to our expert speakers. We have tried our best to capture in a concise way some of the ideas that have been put forward this evening by our speakers, including in the audience. And if you would like to get out your mobile phone or other tablet device, anything that can connect to the internet, and put in the address on the left-hand side of the screen, slido.com. Yeah, absolutely. Absolutely, anyone can vote. And you'll see up on the screen that some of the votes are starting to come in already. You can choose up to 3 of your top priority law reform suggestions of the ideas that we've heard tonight, which ones you think should receive the highest priority. And from the Law Reform Commission's perspective, we should clarify we really appreciate the in-depth discussion about the interaction between the Constitution and migration law, but we are certainly open to suggestions that relate to migration law that don't necessarily have a connection to the Australian Constitution as well. So some of those topics don't necessarily need to have a constitutional hook to become a potential law reform topic by the Commission in the future. So we have an early leader, an early horse out in front, it seems, the citizen assemblies for constitutional reform proposals, the leading idea at this stage. We'll give people just another minute or two to go through those and make their selections. The next will be an opportunity to put in some free text that will just come up in a word cloud for us. If you have other ideas that you wanted to put forward, or other topics that you think should be a priority for the Law Reform Commission into the future. And this will all be valuable information that we will take into consideration in working out which suggestions we can make to the Attorney-General about what might be a future topic of our inquiries. So I say another minute or two on this screen, and then I'll switch over to a free text section, and then I'll leave it to Justin Middleton to close. Thank you very much once again. So we should also mention that this is not the only way that you can have input by being here tonight and by voting here, but also our online survey on SurveyMonkey is the main way that we'll be collecting more detailed ideas from people that we can take into consideration. We've got some handouts at the back which should have that SurveyMonkey address, or by going to our website you should be able to find a link to our online survey where you can put in your own ideas, or again vote on some example ideas that we've put up for discussion to stimulate discussion. Thank you. Thank you. So this is now where you can just put in free text for any other ideas that you have.
Good. All right. Thank you, Michael. I just wanted to thank our panellists for preparing for tonight and attending tonight. So thank you very much. I'd like to show appreciation in all way. Also like to thank the University of Melbourne and the Law School in particular for working in conjunction with the Law Reform Commission to not only put on the night for the people here, but also the live streaming and get ideas in which we can work on. As Michael said, all this, the contributions are very useful. We can get some idea of what other priorities to take place. For my own part, I've always thought that public literacy, knowing about what amendments there are or what amendments can be made, is very important. And Brexit may have shown that if people were more informed before the vote, they may have altered their view. But so it's very important, whatever we have, whatever consultation we have and whatever proposals put forward, there be a lot of public awareness and people are well informed about what should happen. So thank you very much for attending. Thank you again to our panellists, and I think there are other refreshments next door. Excellent. I'll close on that note. Thank you.
Thank you for borrowing their idea. I was at a constitutional convention.